Nanis Burji Damor. You are held guilty for the offences punishable under section 376 2 into bracket F, 376 2 into bracket H, 376 into bracket 2 into bracket H of the Indian Penal Code, as well as section 5 into bracket F, 5 into bracket L, 5 into bracket Q of the Protection of Children from Sexual Offence Act. તમને તકસીરવાન ઠેરવવામાં આવે છે. Yes. The point of contra. इधर आए. લેફ્ટ. હા એ આપી દેજો, વાંધો નહીં.
અને જો આવી રીતના શિક્ષક આવા દુષ્કૃત્યનું કામ સાહેબ સ્કૂલમાં જ જ્યાં ટ્યુશન ક્લાસીસ ચાલે ત્યાં કરતા હોય સાહેબ, એવા સંજોગોમાં પૂરા સમાજને સડો લાગી જાય. એ સમાજનું અવિભાજ્ય અંગ છે અને પૂરા સમાજને એના કારણે સાહેબ સડો લાગી જાય. એટલે સમાજના હિત માટે અને જે આ પોક્સોમાં જે ગુનાઓ બને છે ગંભીર પ્રકારના, એવા ગુનાઓ બનતા અટકે એ માટે સાહેબ સમાજમાં દાખલો બેસે એના માટે કાયદા મુજબની પૂરેપૂરી સજા કરવી જોઈએ.
On the point of quantum of punishment, learned special APP Miss Tina Soni submitted that the offense committed by the accused is a very heinous offense. It is not against the individual but against the society. Full stop. Learned special APP Miss Soni further submitted that the offense is committed extremely diabolical manner. The accused was the teacher in a tuition classes, and the victim was his student. The act of the accused has also defamed the relationship of teacher and the student. This offense is very serious because it is committed by a teacher who is having the status of who is also having the status of guardian. He also violated the relationship of a teacher and student. Full stop. Learned special APP Miss Tina Soni further argued that present accused shall be punished. So the example also set in the society. And lastly, she prayed to award maximum sentence to the accused. He relied upon so and so. This means. Next paragraph. Learned counsel Mr. Shailesh S. Saraya, on behalf of the accused, submitted that
first offense minimum saja
this is a first offense committed by the present accused. Full stop. Accused also having married. Accused also married, having कितने बच्चे?
ना छोकरा छोकरी एक छोकरी
Having one female child in his family. He is only member in his family to earn the rights to his family members. There is also a mitigating circumstances which should also be considered by this court at the time of awarding the sentence. Full stop. The accused is a teacher. Therefore, considering the entire facts, minimum sentence should be awarded to accused. Next paragraph. The scope of section 235 into bracket 2 of the Code of Criminal Procedure was examined by the Honorable Apex Court in case Shanta Singh versus State of Punjab, AIR 1976, SC 238. It was observed by the Honorable Apex Court that, the court must, in the first instance, deliver a judgment convicting or acquitting the accused. Full stop. If the accused is acquitted, no further question arises. Full stop. But if he is convicted, then the court has to hear the accused on the question of sentence and then pass a sentence on him according to law. When a judgment is rendered convicting the accused, he is at that stage to be given an opportunity to be heard in accordance to the sentence. Conviction accused, he is at the stage of क्या लिखा? At stage to be given an opportunity to be heard in regard to the sentence, and it is only after hearing him that the court can proceed to pass the sentence. Next paragraph. The sentencing policy, therefore needs to strike a balance between the two sides and count upon the twin test of number 1, deterrent effects, or number 2, complete reformation for interrogation of the offender in civil society. Full stop. Where the court is satisfied that there is no possibility of reforming the offender, the punishment before all things must be befitting the nature of crime and deterrent with an explicit aim to make an example out of the evildoer and a warning to those who are still innocent. Full stop. There is no gainsaying that the punishment is a reflection of societal morals. The substance of capital punishment proves that there are certain acts which the society so essentially abhors that they justify the taking of most crucial of the rights of life. Next, the Honorable Supreme Court in the aforesaid stated case also note the object and reasons of the recent amendment in section 6 with regard to the punishment in aggravated penetrative sexual assaults, which is observed as under. The minimum sentence for an aggravative penetrative sexual assault has been thus increased from 10 years to 20 years and imprisonment for life, and now been expressly stated to be imprisonment for natural life of the person. Significantly, the death sentence has also been introduced as a penalty for the offense of aggravated penetrative sexual assault on a child below 12 years. Nowadays, there are rising crime rate, particularly of the heinous nature of crimes against the young girls. And in response of the society's cry for justice against the criminals and to have deterrent in the society, the culpability of the accused deserve to be awarded extreme penalty. The present act of the accused was pre-planned manner. There is chances of his reform and rehabilitation. There is no continuous threat to the society. ये निकाल दीजिए. The factual matrix of this case is unfortunately related to the sordid and obnoxious incident where the accused, who at the relevant point of time was working as a teacher, gratified his emanated passions and sexual pleasures by having carnal knowledge of his student, a girl of a tender age. The result was that the scared relation of teacher and his pupil was mesmerized. In case of Madan Gopal Kakkad versus Narayan Dubey and others, 1992 into bracket 2, crimes, page number 168, Honorable Apex Court observed that the such type of offenders are menace to the civilized society. Full stop. The sexual violence, apart from being a dehumanizing act, is an unlawful intrusion of the right of privacy and sensitivity. of a female. It is a serious blow to her supreme honor and offenders her self-esteem and dignity. Stop. It degrades and humiliates the victim, and where the victim is a helpless innocent child of a minor, it leaves behind traumatic experience. Honorable Supreme Court of India also observed in case State of Himachal Pradesh versus Srikant Sekri 2004 AIJE SC 28022 that a rapist not only causes physical injuries but more indelibly leaves a scar on the most cherished possession of a woman, that is her dignity, honor, reputation, and not the least her chastity. Rape is not only a crime against the person of a woman, it is a crime against the entire society. It destroys, as noted by this court in Sri Bodhisattva Gautam versus Miss Subhra Chakravarti, AIR 1996 SC, the entire psychology of a woman and pushes her into deep emotional crisis. It is a crime against basic human rights and is also violative of the victim's most cherished of the fundamental right, namely the right of life contained in Article number 21 of the Constitution of India. The court should consider these type of cases with utmost sensitivity. Next, it is also observed by Honorable Apex Court in case Tulsidas Kanolkar versus State of Goa, Criminal Appeal number 298 of 2003, that while a murderer destroys the physical frame of his victim, but a rapist degrades and defiles the soul of a helpless female. Full stop. When the victim is there is only a physical violence. There is not only a physical violence and degradation and defilement of the soul. Next, it is a duty of the court to impose of appropriate punishment in the manner in which the court responds to the society's cry for justice against the crime. Justice demands that the courts should impose punishments befitting the crime so that it reflects public adherence to the crime. Crimes like the one before us cannot be looked with magnanimity. Next, having regard to the social conditions prevailing in the society, the modesty of a woman has to be strongly guarded by the courts. Any liberal attitude by imposing meager sentences or taking too sympathetical view merely on account of lapse of time in respect of such offences or the age of the accused at the time of commission of the offence, as well as the age of the accused at the time of when the court passes an order of sentence, will be result-wise counterproductivity in the long run and against the societal interest, which needs to be cared for and strengthened by a string of deterrents inbuilt in the sentencing system. We will be failing in our duty if appropriate punishment is not awarded for a crime which has been committed not only against the individual victim, but also against the society to which the criminal and victim belongs. The punishment to be awarded for a crime must not be irrelevant, but it should conform to and be consistent with the atrocity and brutality with which a crime has been perpetrated. The enormity of the crime warranting public adherence, and it should respond to the society's cry for justice against the criminals. Next, the society requires a justice system which not only take care of retributive, preventive, formative aspect of punishment, which is oriented towards the accused, but it needs a system which takes care of the socio-milieu in which the girl and women are safer. That is why Nelson Mandela said, safety and security does not just happen. They are the result of collective consensus and public investment. We owe our children, the most vulnerable citizens in our society, a life free of violence and fear. It is also a duty of the court to restore the criminal justice system and also restore the credibility of the justice in the society by awarding proper sentence to the accused persons. Next, in case of Hazara Singh versus Rajkumar, 2013, into bracket 9 SCC 516, Honorable Apex Court had held. ये मैं दिखा दूंगा आपको. In another case regarding the quantum of sentence, Honorable 3 judges bench of Supreme Court has held in case Ahmad Hussain Wali Muhammad Sayyid versus State of Gujarat, 2009, SCC 7, page number 254. एक लिखा है तभी. The object of awarding appropriate sentence should be protect the society and to deter the criminal from achieving the avowed object to law by imposing appropriate sentence. It is expected that the courts would operate the sentencing system so as to impose such sentence which reflects the conscience of the society, and the sentencing process has to be stern where it should be. Any liberal attitude by imposing major sentences or taking too sympathetical view merely on account of lapse of time in respect of such offences will be result-wise counterproductivity in the long run and against the interest of the society, which needs to be cared for and strengthened by string deterrents inbuilt in the sentencing system. Justice demands that court should impose punishment befitting to the crime so that the courts reflect public adherence to the crime. The court must not only keep in view the rights of the victim of the crime, but the society at large, while considering the imposition of appropriate punishment. The court will be failing in its duty if appropriate punishment is not awarded for a crime which has been committed not only against the individual victim but also against the society to which both the criminal and the victim belongs. So, after considering the relevant factors and the circumstances, and the reasons and findings recorded above, this court comes to the conclusion that this case conclusion that this is a case of serious nature. Accordingly, on the reason recorded above, I pass the following order in the interest of justice. Order. The accused Nanesh Bhurji Damor is hereby convicted under section 6 of the Protection of Children from Sexual Offences Act, वो अपना 6 का मुझे बताइए। मेरा मोबाइल नाम हाँ, इसमें सही खुलेगा नहीं तो मोबाइल दे यस क्या लिखा है आपने?
under section 6 of the Protection of Children from Sexual Offences Act.
सेंटेंस विद ये read कर देना, पीछे कॉल आ जाएगा। सेंटेंस वो निकाला था ना, एक तुमने प्रिंट मुझे दिया था। ये हाँ, क्या सेंटेंस अपना?
It is convicted under section 6 of the Protection of Children from Sexual Offences
Convicted
Act.
under the provision of section 235 into bracket 2 of the Code of Criminal Procedure for the offense punishable under section 6 of the POCSO Act to undergone imprisonment for life, which shall means imprisonment for remainder of natural life, means till his last breath. And fine of rupees 1 lakhs in default of payment of fine, he shall further awarded simple imprisonment for a period of 6 months. Next, in view of the provisions of section 26 of the General Clauses Act, section 71 of the Indian Penal Code, and section 42 and 42 into bracket A of the POCSO Act, the accused is not sentenced separately for the offenses punishable under section 376 into bracket 2 into bracket F, 376 into bracket 2 into bracket H, 376 into bracket 2 into bracket N of the Indian Penal Code. The fine amount, if realized, be paid to the victim as compensation in addition to the compensation awarded under the Victim Compensation Fund Scheme as per the provisions of section 6 into bracket 2 of the POCSO Act. A copy of this judgment be supplied free of cost to the convict forthwith. As contemplated under section 365 of the Code of Criminal Procedure, the office is hereby directed to send a copy of this judgment to concerned district magistrate, Dahod. Next, compensation. Now coming to the aspect of compensation to the parent, to the victim. The Honorable Supreme Court has time and again observed that subordinate courts trying the offences of sexual assault have the jurisdiction to award compensation to the victims, guardians, parents, being an offence against the basic human right and violation of Article 21 of the Constitution of India. The government of Gujarat also issued notification number GG/2019/SB.com/132018/663 on dated 26 April 2019, exercising the powers conferred by section 357 into bracket A of the Code of Criminal Procedure regarding scheme for providing funds for compensation to the victims or the dependents, oblique guardian, oblique parents of the victims who have suffered loss of injury on account of an offense against body and who require rehabilitation. The victim cannot be compensated in terms of money, but it will definitely help them to some extent to restore the loss of dignity of a woman. While fixing the amount of compensation, this court is guided by principles of as provided under Rule 9 into bracket 3 of the POCSO Act, Rules 2020, including the type of abuse, gravity of offense, and severity of the mental and physical harm and injury suffered by the victim. After taking into consideration that totality of the facts and circumstances of the case, and in exercise of power under subsection 8 of section 33 of the POCSO Act, and conjoint reading of section 357 into bracket A of the Code of Criminal Procedure, this court is opinion that the victim should be awarded an amount of rupees 2 lakhs for the loss suffered by her from the Gujarat Victim Compensation Fund established for the purpose of compensating the victim. A copy of this order also be forwarded to Learned Secretary, District Legal Services Authority, Dahod, for information and necessary action under the intimation of this court forthwith. It is hereby ordered that the all non-valuable muddamal are hereby destroyed, disposed of after the completion of appeal period, as per the provisions of section 452 of the Code of Criminal Procedure. The Muddamal article number, Muddamal article, mobile phone, make Oppo company, is hereby ordered to be handed over to the wife of the accused after due verification. Pronounced in the open court on this 29th. बाकी ये बेल है. ये सब मेरे को नीचे जी.
પણ આ સાહેબ ડાયરેક્ટ લખો તો વચ્ચે હું કેવી રીતના બોલું? વચ્ચે બોલવા જેવું તો સારું નહીં લાગે. હું લઈ લીધું.
જે છે
હમ.
મોબાઈલ આધારિત છે. મોબાઈલ અને બાઇકથી આધારિત છે. એના આધારે જે સીડી બનાવી તારો એવિડન્સ શું
મોબાઈલ